too, if you.
Yeah. Today's meeting of the Municipal Code Enforcement Board is called to order on agendas of today's meeting are on the wall to the entrance at the chambers, and please remember to turn off your cell phones. The Municipal Code Enforcement Board consists of 7 members who are appointed by the City Council, and we serve voluntarily. It is this board's intention to promote, protect, and improve the health, safety, and welfare of the citizens of Clearwater by providing this equitable, effective, and inexpensive method of enforcing certain codes within the city. The board considers new business items in 2 parts. First, a violation and then affirmative relief. Formal rules of evidence do not apply, and each side is limited to 15 minutes. The board may grant additional time. All proceedings will be conducted in a calm, civil manner. Individuals who conduct themselves otherwise will be asked to leave. If necessary, they will be escorted from the chambers. Now I ask all who plan to speak, please rise and be sworn in by the clerk.
Do you swear or affirm to tell the truth throughout your entire testimony?
Our first order of business is to approve the minutes from last month.
I so move.
Second.
All in favor?
Aye.
So moved. Is there anyone here to speak to items not on the agenda? Next on the agenda are new business items, and we're taking the first one out of order. Item number 4.30, case 55-20. 5 respondents, Zahid Roy at 933 Laurel Street, in violation of codes for permits, and issue an order with compliance deadline and fine if compliance is not met.
Morning, Board. Nilda Espinosa, Housing Inspector for the City of Clearwater.
Sorry, first we have the applicant or the respondent. You admit or deny?
I don't know what it is yet. We don't know code for permits?
What did you say, do you admit or deny?
Yes.
Good morning.
They're asking whether you admit or deny the violation after you introduce who you are.
My name is Benjamin Roy. I'm here on behalf of my father, Zahid Roy, regarding this case. The respondent denies any violations of code.
Thank you.
Okay.
Good morning, Board. Nilda Espinosa, Housing Inspector for the City of Clearwater. I'm here to present a case for 933 Laurel Street. This is a stop work order. Just bear with me for a moment, please. This is case 55-22. This is for a stop work order, which is permits are required, and work was commenced without a permit. Notice of violation, first one was sent on December 12th, 2019. I had to send a second one on January 10th, 2020. Compliance date for the first notice of violation was January 3rd, 2020. Second violation compliance date was January 30, 2020. Certified mail was sent first time and was returned by the post office. Second time was sent and I received it back on the 23rd of last month. It was also sent regular mail. Notice the hearing was sent on the 10th of last month. Again, certified mail for that was also received on the 23rd. An affidavit of posting for the notice of violation and hearing was done on January 10th last month. This is where the property is located. Excuse me. It's behind Cleveland It's just, it's behind the paint store that's on Cleveland. And it's on Laura. This is a picture showing new siding being put in. This is the front of the business. This is an interior picture that was taken through a window. There were no coverings on the window, no blinds, no plastic, no curtains, nothing. The window, you could clearly see through it. You can see here that there is plywood, there's sawdust, there's drywall. Here goes a window that has been framed in. Another one. There were 5 windows at one time on the west side of the building. This is a Google photograph from January 2019, showing 5 windows. 2 are gone. What they did with them, I don't know. Closed them in. But you can see that street. This is the notice of the poster. And leave it up to you.
Madam Chair, may I ask a few clarifying questions?
Certainly.
To the inspector, perhaps, and also Mr. Root. Inspector, have you had occasion to see Mr. Roy's answer to petition that I'm holding up here?
I did read some of it, yes, sir. Excuse me.
Okay. So I just want to go through it a little bit with you to see if you agree with any of the points. The first thing is he talks about the interior remodel, and I just want to clarify, did you go inside the property?
The first time I went, no one was on the property. I went the second day, no one was on the property. That's when I noticed the windows, I took photographs, I went back to the office.
But the question is, did you go
And then
inside?
The third time I went there was a female in the office. I think it was an office, but there was a female inside. And he told me he was his son, he was outside, and when I told him I was there, the garage door was closed immediately. No, I never got inside.
So all those pictures that you took were through the window?
Yes, sir.
Okay, and you just took things, pictures of things that were in plain view?
Yes, sir.
Now, you see that Mr. Roy denies that the interior has changed since he purchased the premises, and that his answer says that he purchased it on September 10th, 2015. In your measured expert opinion as a code inspector, do you believe that the interior remodel that you took photos of could have occurred in the last, more than half a decade ago?
No.
Okay, and that's because of the quality of the wood
Yes,
and
sir.
all those debris and
Yes,
things
sir.
that you saw around there? Okay, thank you. Going down to the second point of his petition, he talks about the removal of a window. And Mr. Roy cites the city's Community Development Code Section 3-1502C, which requires windows to be maintained in workmanlike manner. You're familiar with that code requirement? Are you familiar with that?
I'm sorry, say
Are you
again.
familiar with the Community Development Code Section 3-1502C, which talks about windows having to be kept in an enclosed manner, in a workmanship manner?
They have to be in a working condition?
That's correct. But that's not the code section you cited them for, correct?
No, sir.
And you cited them for work without a permit. That's different, and that's a different code section.
Yes, sir.
So when they talk about that code section 3-1502C, that has no bearing on the case.
No, sir.
And these last questions, if I may be directed to Mr. Root.
Certainly.
Sir, would you state your name for the record?
My name is Dana Root.
Okay, and what is your position with the city?
I am the assistant building official.
And could you just briefly explain some of the duties, your job duties and description that you have as an assistant building official?
I'm the assistant building official, and I take place in case I take place of the building official in case of his absence, and Our office administers the Florida Building Code, the Clearwater Community Development Code. In my position, I supervise building inspectors, housing inspectors. My department handles all of the unsafe structures in the city of Clearwater. The building official and I are the people that determine whether a permit is needed or not.
And so in that capacity, are you familiar with Chapter 47 of the Clearwater Community Development Code?
Yes.
And more in particular, are you familiar with Appendix A of Community Development Code, which is cited in Mr. Roy's response, which talks about permits not required for paneling and things of that nature?
Yes.
And in his response, which is on page 3, which if you had occasion to look at the response, sir?
Yes, I did.
All right. And is the code that's actually cited in the response, that's not the full code, is it? Yeah, and I'll read it for you. It says permits, ... not required for ... paneling over existing walls, ... nor where the valuation of labor, materials, and all other items does not exceed $500, ... That's not the full code section, correct? Okay. And I'll read it for you, and you can tell me if this is the full code section. Permits are generally not required for carpeting, painting, wallpapering, paneling over existing walls, and tile, nor where the valuation of labor, materials, and all other items does not exceed $500, and the work or operation is of casual, minor, inconsequential nature, and does not violate any city codes or ordinances, or is exempt pursuant to Chapter 75-489 Laws of Florida, Special Act, Section 25. Is that the full code section?
Yes, it is.
All right, so really the code's talking about where generally permits are not required.
Correct.
Okay. And in this case, a permit was required,
Yes.
and why was it required?
For the exterior work, they altered the envelope of the building. They closed in windows with framing, added sheathing, and then added siding over those openings. They installed new siding. You can see the lower part of that, the lower part of the building has a panel on it. It appears to be a hardy board type product, which is a siding product. And it appears that they're doing some sort of interior remodel with new framing. That one picture that showed the drywall behind that. It looks like they have some new framing, and looks like they're building some sort of room.
And to break it down just a little bit, when we talk, going back to that code section that's cited in Mr. Roy's response, it talks about paneling over existing walls. Is that referring to exterior or interior walls?
That would be interior. Typically, paneling would be put over drywall or plaster on the inside of a structure.
And that would generally not require a permit.
Correct.
But paneling on the exterior, which is what we have here, does require a permit.
Siding.
Siding.
Would be, yeah, it would be siding.
And then when we talk about the value of the labor, materials, and other items not exceeding $500, that also requires the work to not be casual, minor, or inconsequential nature, correct?
Correct.
And in your measured expert opinion as the assistant building official for the city of Clearwater, was this work minor, inconsequential, or casual?
No.
And why is that?
Because an example would be if you replace a window on a building, and the window just happens to cost $200, and it costs $100 to put the window in. So you're under that $500 threshold, but that work is not minor. So you still need a permit even though you're under that $500. An example of when you would not need a permit would be a repair of a roof. You have a hole in your valley, and a roofer can fix that for $400, and that is minor.
And just one final question, just to conclude, the gentleman would need a permit for the interior remodel, for the removal of any windows, and for the siding on the exterior.
Correct.
No further questions. Thank you very much.
I have a question, if I may. Just for clarification, you said there were two
stop work orders posted?
No, it was a stop work, I guess I sent a notice of violation.
Right.
It came back from the post office, that goes registered mail. I waited to see if there was any contact, no contact. I sent another notice of violation with a notice of hearing. That made it through to the address that's listed on property appraiser. They signed for it. I got the return receipt card, the green card they call it, back. That's when they made contact.
Okay, thank you.
Yes, sir.
Okay. Mr. Roy? After hearing the issues involved, you still deny the allegations?
I do.
Okay.
And if I may use the, please.
Get closer.
You have to forgive me, my boards are a little bit bad on the printer, but here's a picture of building now. Now, Mr. Fiano asked the inspector regarding Development Code Section 3-1502, subsection C, property maintenance requirements regarding the enclosing of a window. And I'm sure you've read it. The provision is as long as the frames are removed and the wall that is adjoining the window that is being enclosed is repaired in a similar manner as the rest of the wall. Now, the inspector said this has no bearing on her case. But if this is property maintenance, and this is coming from the code, I don't really understand that. I do like to bring up, though, I'm glad Mr. Root was here today to explain that. It's brought a lot of clarity to the case. Last time we tried reaching out to Mr. Root, he called in sick, and I'm glad you're feeling better. I do have a statement, though, I would like to read if that's okay.
Go ahead.
First thing I'd like to address is the code the respondent has allegedly violated. That's section 4-203, subsection A, clause 1, and section 47.083, subsection 2 of the Community Development Code. With 47, it's contingent upon the respondent being found in violation of section 4.203, subsection A, clause 1. Which states, no person shall commence any construction, demolition, modification, or renovation of a building or structure without first obtaining a building permit. Section 8-102, Community Development Code, provides definitions for words and terms for the purposes of the Development Code, with any words and terms not defined in that section being, quote, indicated by common dictionary definition, pursuant to section 8-101, subsection N. With the definition of building and structure defined in the Development Code, the word modification is not defined. Thus, the meaning is subject to the indication of common dictionary definition. I have a Webster's dictionary with me today. I've looked into it, and the definition of modification is a modified or being modified, specifically a partial or slight change in form or content. Modification is synonymous with the word change. Did the respondent modify or change the building at 933 Laura Street? I think that's undeniable. But this is a pretty vague standard set by the city, one that can be applied almost universally to any building. Section 4-203, subsection A, clause 1, mandates the respondent needs a permit to modify or change the building. If we were to play the permit game, to do anything with the building, which could be as little as painting a window molding, the first thing the citizen may be wondering is how much this may cost, which brings us to Appendix A, which is directed, Appendix A of the City Code, which is directed from Article 4, Division 2, Section 4-203, subsection A, Clause 1. And eventually you get to section 4-202 subsection F, fees. Quote, all applications shall be accompanied by the fee established and maintained as Appendix A to the city code. That's where we finally got to, we generally don't need a permit for this work. Not only did we fulfill the one requirement of, well, at least we thought we did, of it being paneling over an existing wall, but we also felt that we were in compliance with under $500 threshold. If you look at Exhibit C, there's the breakdown of the costs, with the labor being free, volunteer. Property rights, I firmly believe, my father's an immigrant, and I grew up in a household where we abide by the Constitution. Property rights are what made this great nation great, and it was one of the reasons why it was founded. It's not illegal for the respondent to maintain his property, and in fact, we discussed this in section 3-1502, which sets out the standards for which the respondent is expected to abide by. Madam Chair, I'm sure you've seen my father here many times before, and usually those violations surrounded property maintenance. Understandably, it would be in his interest to be proactive regarding the upkeep of his property. 933 Laurel Street was the only property owned by the respondent without any property maintenance violations on it. First it was 1412 North Fort Harrison Avenue. Then the city went over to 700 Minnesota Drive and hit him with a repeat violation. We sold the 700 Minnesota Drive in December or late November, and we had a stipulation agreement with Mr. Fiano. Oh, Fiano? Fuino? I apologize. With Mr. Do you mind if I call you Michael or Mike? I apologize.
That's what we call
Michael?
What?
Okay. With Michael, and that's why we moved the material for the that was inside the property at the time. We moved it to 933 Laurel Street, which is what was inside the windows. If we take a look at section 3-1502, subsection C, clause 3 and clause 4, those are the standards for Clearwater property owners surrounding the maintenance expectations of the city for door and window openings. And it clearly says, no windows shall be permanently removed and enclosed unless treated as an integral part of the building facade using wall materials and window detailing comparable with any upper floors in the building facade in general. Clause 4 continues by saying door and window openings not facing the public right-of-way shall be similarly maintained and repaired as the doors and windows facing the public right-of-way. Such doors and windows may be enclosed or removed provided the frames are removed and the opening properly closed to match and be compatible with the design of the adjoining wall of which the opening is a part, as I've explained. Madam Chair, the respondent has complied with this city code, or community development code, to make sure that he wasn't hit with another repeat violation for lack of maintenance. The city, I hope, sees this as the respondent being proactive regarding maintenance of the property. But instead, we feel like we're being charged with an ambiguous code whose standard is, the bar standard is so low. The city goes as far as violating the respondent's due process, neglecting to get an inspection warrant signed by a judge, as required by section 933.20 Florida statutes and Florida Constitution Article 1, section 12. To gather evidence just to claim the respondent, a medically disabled man with 5 herniated discs, has done all this work inside by himself. As soon as the respondent sells one of his properties to settle a lien imposed by the city goes after the respondent's other property. Now the city's defense is you inherit any violations left by the previous owner. But my question is, where has the city been for the last 4+ years? Florida statute of limitations, as I've explained, and the answer is 4 years for action on, quote, the design, planning, and construction of an improvement to real property, end quote. Any change the respondent did, even to, quote, strengthen the city's economy and increase its tax base as a whole,
Do you have a lot more to say?
Not very much.
Okay, please.
Yeah, you should stick to this case, not other cases. You know,
Well, I
I was here
appreciate
on
your
all those
input.
cases when your father was here,
Yes,
so those are separate cases. This
Okay.
case right here is for this property.
I'll keep
That's
that
right.
noted.
Yeah, I would note that.
Okay, thank you.
You're welcome.
But statute of limitations is 4 years for the design, planning, or construction of an improvement to real property. And what the respondent did was to strengthen the city's economy and increase its tax base as a whole. That comes from section 1-103 of General Purposes Community Development Code. It is the purpose of the development code to look after the general welfare, as you stated, Madam Chair, and enhance the quality of life of all property owners of the city. And the respondent feels that this is an exploitation of ambiguous code by the city when there is unambiguous code coexisting that will clear the respondent of any wrongdoing. We feel the city is not looking after the general welfare and quality of life for the property owners, it's looking after its own pocketbook. I promise you what the respondent has done to his property will increase his property taxes, and the city can get their money through that. In short, what the respondent has done, we feel he's been following the book. And what the city has done is gone off the books, violated his civil rights, and now is going to punish the respondent for not following the book. And I hope this body sees that and dismisses this case. Thank you.
I have a question for inspectors. Please state yourself. Yes, ma'am. How did you become aware of this situation?
It was a phone call that was made to the office and the case was opened up.
Okay, thank you. So that is how the city became aware of the situation on this property, okay? So it wasn't the city following your father and all his properties and a little checklist and all that. That didn't transpire. Okay? The other thing is you talk about increasing the tax base, but at the same time, the way it works is unless you get a permit, they don't know about it, that they don't increase your property value based on that improvement. The rest of this patriotic diatribe that you gave us, we don't need that. You have to ask one question.
Sure.
Why does your father have so much difficulty complying with the code? You would think with all the experience that he's had, personal that he had to do with, that he would know what the code is by now.
Sure, and that's exactly as I stated, sir. He's had experience with the property maintenance issues, and he's trying to be proactive, and as soon as he's being proactive about it, you run into this issue.
Your father told us once that this is what he does for a living. He buys properties, he improves them,
And he got into a
and he
car.
sells them. That's his business.
That's
Good
right.
for him. I admire that. But if he's gonna do it right.
Mhm.
Not the way he thinks is right, but the way it is right.
Well, that's why we
It's
refer to the
public
book.
information and he has access to it.
That's why we refer to the book. Thank you, sir.
Sir, if I may,
Yes, sir.
how many windows did your father take out?
2 windows, sir.
He took them out.
Yes, and the code notice of violation said 1 window.
He took them out, and then what did he do? He covered them over?
That's right.
And to you, in your mind, that's maintenance?
To
That's
me, in my
general
mind,
maintenance?
that's the closing of a window pursuant to the city code, community development code.
Answer my question. You, in your mind, that's general maintenance?
That's under the code, sir.
To take out a window and then cover it over with siding?
That is not general maintenance. Maintenance is broken pane, you replace the pane. Okay? If it's leaking, you caulk around it, all that, that's maintenance.
Sir, it's under the community development code as under a maintenance section.
I think for you to come in here today and preach to us, is the wrong approach for you. I think you could resolve this by complying.
Well, we tried to reach out to the city, and what happened, as I explained in the answer, is that as soon as we tried to set up a meeting with the city, at first there was no meeting, and then Mr. Root reached out and said, okay, let's set up a meeting. We set up a meeting, Mr. Root called in sick, and
Okay,
I understand things
understand
happen.
that, but you're before the board now,
That's right,
and we can help you
okay.
if that's in you to
Absolutely.
do.
It's in my interest to cooperate with the city, and that's exactly what I want to do.
That's how we can help you. Comply. Do what the city's asking,
Okay,
and we could probably work with you on time.
okay. That's fine.
Wait, we're in the first part of your hearing,
Right,
so we need to address the first
Yeah, we're
issue.
getting ahead.
okay. Do I have a first motion?
Yeah, it's coming up. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Aye. Motion carries. Okay.
Here's the recommendation.
Now, what is your recommendation, Mrs. Reynolds?
Okay, for this case, 5520, one violation, compliance on or before March 27th of 2020, or $150 per day per violation, which is just the one. And after 3 months from recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
So what you're looking for is for them to get a permit to do the work,
Yes, sir.
okay? So let's say they don't do anything. They just stop. They say, enough's enough of this, we're not gonna do anything.
Yes, sir.
Okay, and they haven't commenced work. But in order to commence work, they have to have a permit.
Yes, sir.
That's clear? Yes. Okay,
Can we get the recommendation?
no?
The work has already been done.
No, it's not the work getting done. Can you explain what they have to do to come in compliance?
They need to get a permit for closing in the windows,
Should
the
be on the
siding,
slide.
and the interior remodel. Now, the city would be open if the property owner would let us in the building to take a better look, and we could evaluate what they're calling storage. You know, if you truly claim that you're not doing an interior remodel.
Sure. I mean, I'm not authorized to grant you that, though. I'll have to speak with my father and get back to you. I have your email, though.
Well, I mean, you're here, Mr. Roy.
We need to make a decision.
You said you're your father's representative. You just testified on his behalf, so. It's right hand, you not speak for him.
I cannot speak for him on that issue.
Why not?
Okay.
Okay, that's fine.
But I'll be more than happy to get back with Mr. Rue
All right.
via email.
Second motion.
I move to enter an order requiring the respondent to correct the violation on or before March 27th, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. Motion carries.
Thank you.
Okay, now we'll go back in order. Okay. Item 4.3, case 26-20, Precision Hotel Management Company at 212 South Hillcrest Avenue, in violation of code for exterior services, and issue an order with a compliance deadline and fine if compliance is not met.
Well, the property did look like that, so I
So would
was
you
guilty,
please
but I have
what's your
since
name?
then.
Ma'am?
Your name? Oh, Virginia Mitchell.
Okay.
Your address, please?
The address? 212 South Hillcrest.
Now, what is it that you said?
The inspector came out, the building needed to be painted and some things needed to be fixed, so I do admit that that was a problem. I have since then fixed it.
Is this a declaration?
No, it's not, but I'm sure that Ms. Mitchell has gotten things taken care of. I just haven't gotten to lay eyes on the completed product yet, so I'd like to, if the board makes a finding of violation, I'll make our recommendation and I'll get back out to take a look and see, but we spoke today, so I think it's gonna be in compliance, but I haven't gotten to lay eyes on it yet.
First motion.
Yes.
So I move to find respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay. Ms. Brown.
One moment. Okay, Shelby Brown, Code Inspector, City of Clearwater. This is for case 26-2020 at 212 South Hillcrest. This is our recommendation. The violation was for exterior services. This is a multi-unit rental income property, part of our downtown gateway sweep we did recently. And I was requesting compliance on or before March 26th of 2020, or a fine of $250 per day for each day the violation continued to exist. I was asking for a higher fine because it's a multi-unit rental property, although I'm sure it's going to be in compliance and will be in good shape. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. I'll show you a few quick pictures of what it was like, okay? And they have made a lot of progress out here. Compliance can be met for the exterior surfaces by having any damaged or deteriorated structural and decorative elements repaired and or replaced in a workmanlike manner. So that includes stucco, trims, soffits, fascia, etc. Removal of all mildew, peeling paint, and other loose materials, and repainting of all affected areas shall be accomplished to match the existing or adjacent surfaces. And the building walls shall be maintained in a secure and attractive manner. These pictures, I'm sure things have changed, but this was just the pictures I took on the 19th of what remained to be done. The front of the building looked great. Back of the building a week ago, not so much. We had a lot of soffit and fascia areas that were in rough shape, mismatched paint. Some pretty good holes existed in the back of the fascia there. This was pretty consistent throughout the back of the property. The walls were mildewed, kind of whitewashed. They needed to be repainted so that they look like the front of the building, which looks super. Here's another picture of some missing wood and just some more issues with the exterior surfaces. And then here's a sidewall that shows it needs to get painted, just some mismatched paint. And Ms. Mitchell has assured me that everything's been sorted out. So I'm requesting compliance by March 26th. Okay?
Have a motion?
Second motion?
I move to enter an order requiring the respondent to correct the violations on or before March 26, 2020. The respondent does not comply by that date, the board may order a fine of $250 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
All in favor?
Aye.
Opposed? Motion carries. Thank you for coming in. You've got to jump on finishing.
Yeah, it's already done, but thanks so much for working with me, I appreciate it.
Right, okay, thanks. Okay, case 4.5, or item 4.5, case 28-20, Sean O. Dickerson at 2329 Pine Oak Lane in violation of code for short-term rental and residential rental business tax receipt, and issue an order with the compliance deadline and fine if compliance is not met. Is Mr. Dickerson here?
He's not, and Madam Chair, the property is currently in compliance and requesting a declaration of violation.
Okay.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing. And to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 a day for each day the violation continues to exist.
I have a second. I'll second. All in favor? Motion carries. Okay. Item 4.6, case 29-20, Sami Cahoon at 1407 North Betty Lane in violation of code for sign maintenance and issue an order with a compliance deadline and fine if compliance is not met. Mr. Knight, is he here?
I don't believe that they're here, but the property is in compliance and the city is requesting a declaration of violation for this case.
Okay.
I move to find the respondent with a violation of the code. The code is referred to in the affidavit in this case. The violation was corrected prior to today's hearing. Enter an order that no fine be imposed. The respondent repeats the violation. The board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Aye. Motion carries. Or, yeah, right. Item 4.7, Case 30-20, find respondents William Mickle Jr. at 1496 South Missouri Avenue in violation of code for signage without permits and issue an order with compliance deadline and fine if compliance is not met. Are they here?
Compliance has been met on this property as well, so the city is also seeking a declaration of violation.
You're making our job easy.
Yes.
I'll move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Motion carries. Item 4.8, case 31-20, find respondents SCC and Associates LLC at 1701 Drew Street in violation of code for signage without permits and issue an order with compliance deadline and fine if compliance is not met.
Compliance has been met on this property as well, and the city is seeking a declaration of violation.
Okay.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Motion carries. Item 4.10, case 33-20. Find respondents Dora and George Callis at 327 Coronado Drive in violation of code for signage without permits and issue an order with compliance deadline and fine if compliance is not met.
Compliance has been met at this property for the violation, and the city is requesting a declaration of violation.
Okay.
Well, you're on a roll, huh?
I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor?
Aye.
Motion carries. Item 4.11, case number 34-20, find respondents K&P Clearwater Estate 2 LLC at 229 Coronado Drive in violation of code for sign maintenance and issue an order with a compliance deadline and fine if compliance is not met.
I don't believe anyone is here for it.
Okay.
The compliance has not been met.
Okay. And first, yes.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries.
Daniel Knight, sign inspector with the city of Clearwater. This is case 34-2020, and there's one violation for sign maintenance. The city is asking compliance on or before March 26th of 2020, or a fine of $150 per day that the violation continues to exist. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met for sign maintenance by repairing and or replacing the sign so that it's in a good condition, free of any damage, rust, discoloration, fading and or peeling paint or other elements. Removal of the sign will also bring compliance. And here are just a few shots. It is the Sunrise Resort. This is a far away shot, close shot. It just needs a little care. There's some peeling paint, faded paint. The pole itself has some rust. It needs to be painted. This was on 2/19. No progress had been made.
Want to make a second?
Sure.
I move to enter an order requiring the respondent to correct the violations on or before March 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day, each violation continues to exist. If fines and fees remain unpaid 3 months after such a lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion carries. Okay. Case 35-20, Roma Square Inc. at 2001 Gulf to Bay Boulevard in violation of code for sign maintenance and prohibited signage, and issue an order with compliance deadline and fine if not met.
All of these violations have been corrected, and the city is requesting a declaration of violation for them.
Okay.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing and to enter into order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Motion carries. Case 36-25, respondent Sophie Nucretis at 29 Avalon Street in violation of code for temporary sign and issue an order with a compliance deadline and fine if compliance is not met.
I don't believe that they're going to show up. I have spoken with the property owner's daughter and the business at this property. I haven't been able to get back out to the property, but they assure me that it is in compliance, but being that I can't verify that, I'm still suggesting that it is not in compliance.
First motion.
Okay.
No.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay.
All right. Daniel Knight, sign inspector with the city. This is for 29 Avalon Street, case 36-20. And it's one violation for temporary sidewalk signs. The city is asking compliance on or before March 11th. It should be 2020, which is 2 weeks. So compliance for March 11th of 2020, or a fine of $150 per day that the violation continues to exist. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. Compliance can be met for the temporary sidewalk signs by refraining from erecting any sidewalk sign outside of the business at the property until an approved sidewalk sign that is permitted and can abide by all the criteria and limitations presented in Table 3-1806-1A of the sign ordinance is obtained. These are just some shots. This was on 10/15. The arrows show multiple sidewalk signs erected out in front of the business. One business is one allowable business, which a restaurant would be one, is allowed one sidewalk sign that can be permitted. Here's another one on January 6th. No permits have been obtained. And then another one on 2/19. Like I said, both the owner's daughter and the business owner has talked to me, and they told me that they are going to keep them inside the building.
Can I make just a general comment?
Yes.
As I came to today's meeting on Mandalay, let's say further south, 2 blocks south of that, there's a whole bunch of restaurants now. Some of them have outside seating, and in addition to that, now they're adding signs. And in one spot there, one person can get through.
Yes, one is very
this
large.
This is getting worse instead of better, and it's not that you're not doing your job, but they're out there.
I am aware of that particular business, and we are enforcing on them. If they choose to correct the violation or not is up to them.
All right, second motion? I move to enter an order requiring the respondent to correct the violations on or before March 11th, 2020. If the respondent does not comply with that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion carries. Case number 37-20, Mary G. Realty, Inc. at 490 Mandalay Avenue in violation of code for business tax receipt required and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
I don't believe so.
Okay.
Declaration.
It's not. They are still in violation. I'd like to go through a little bit more of the photos than I normally would, just to show why.
First motion, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay.
All right, start down here. All right, this is case 37-20 for 490 Mandalay Avenue. It's one violation, which is a zoning violation. of not having a business tax receipt and delinquent business tax receipt. The city is asking compliance to be met on or before March 26th of 2020, 2019 is going to get me all that, or a fine of $150 per day that the violation continues to exist. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. All right, compliance can be met for the zoning violation of BTR being required and delinquent BTR by making sure that all businesses operating at the property obtain a current business tax receipt and renew their business tax receipt by September 30th each year that the business remains in operation. All businesses at the property must obtain a business tax receipt that accurately represents the type of business and service that's being provided. Very specific with that because at the property, we'll go here. The two businesses that are in violation at the property are Rolls and Treats and the Cava Beach Bar. Rolls and Treats has a delinquent business tax receipt. They haven't paid for the current year. And then the Cava Beach Bar does not have a business tax receipt to operate as a cafe. When the violation was sent out, after some back and forth, a representative from the Cava Beach Bar came in. They obtained a business tax receipt, but they obtained one for managing Rolls and Treats. So I'm not sure why, but this is just, I will show you on the 19th I was able to go out to the property. The manager on duty allowed me to go into the Cava Beach Bar and take photos. It is a beach bar. They serve, coffee, tea, whatnot, but it's definitely not a management company. So the BTR that they've obtained has nothing to do with the Cava Beach Bar. So that's where the confusion may have lied. I tried getting in contact with...
Is there a difference in price for that license versus another license?
Yes, the business itself as the cafe would be one category, and then having a pool table is another category that would be added, and then having all these other like dart games, each little game would be a different price compared to what they paid for just being maintenance.
Is this a separate entrance, separate building from the...
No, well, it should be. The
But
issue,
it's not, is it?
No, the issue is that they have taken what was 3 units and made them into one. And the Rolls and Treats, they've actually taken the hinge off of the door, so you can't go in and out of it, and there is, as you can see, an ice cream bar behind it. So you wouldn't be able to access that actual business. You'd have to go into Cava Beach Bar to get to Treats and Rolls, or Rolls and Treats.
So you get Rolls and Treats, play pool, and go get a drink.
I guess so.
And then go out the back door to the beach.
So I appreciate you letting me go through that.
Now, the people, Mary G. Realty are the people that own the building.
They own the parcel of land.
Right.
Yes. And they are very much aware. They've come in, I've spoken with them on the phone, in person.
They've been cooperative.
They've tried. I mean, they did get the tenant to come in and obtain a BTR. It just wasn't one for the business that's being operated there.
Second motion.
You know what needs to be done?
I move that an order requiring the respondent to correct the violation on or before March 26, 2020. The respondent does not comply by that date, the board may order a fine of $200 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. Motion carries.
Thank you, board.
Thank you, good job.
Busy kindness.
Good.
Case number 3820, Sean Curler and Dennis Beveridge at 810 Lake Forest Road in violation of code for roof maintenance, and issue an order with compliance deadline and fine if compliance is not met.
Good afternoon, ladies and gentlemen of the board. My name is Sam Kushep. I'm an attorney here representing the interests of Mr. Curler.
Would you spell your last name, please?
Kusha. Yes, ma'am. So first and foremost, my client has every intent of becoming compliant. It's my understanding that the violation is for roof maintenance of the subject property. To that end, my client has actually entered into a contract and retained a roofing company to prepare those repairs to the property. However, right now that roofer is, I also represent that roofer. We're amidst litigation against the insurance company for the storm-related damages. The insurance company presently doesn't want to pay out or value the roof at the full replacement price, and so we're advocating on the Mr. Curler's behalf to go ahead and secure all proceeds from the insurance policy so that the roof can be repaired and brought back into compliance.
Sir, was that an admit?
Excuse me?
You do admit?
Yes, sir. Further, it's my understanding that a colleague from my office, Mr. Brandon Pfizer, has been in contact with Mr. Fuino, and that they have been able to tentatively negotiate a 9-month extension in terms of compliance to allow us to advocate on Mr. Curler's behalf to wrap up not only the underlying lawsuit, but also commence repairs and complete them at the property. Further, per those conversations, Mr. Fuino made a statement that additional procedural mechanisms need to be articulated and discussed. So I'm here today to represent Mr. Curler and see what needs to be done to solidify that 9-month extension and, be transparent and work with the board to get this into compliance as soon as possible.
I'll make a first. Okay, I'm going to make a first motion. I move to find a respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay.
Good afternoon, board. I'm presenting case 18 Lake Forest Road for Stephen Delavolpe. He just became a new dad, if you're not aware, so I will be taking the case, and it's 38-2020. There is a violation for roof maintenance and requesting compliance on or before November 26, 2020, or a fine of $150 per day. We are asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies under the law. Compliance can be met for the roof maintenance by removing the tarp and maintaining the roof in a safe, secure, and watertight condition. This is a portion of the roof. As you can see, there is a large tarp located on the roof, and that was taken on October 3rd of 2019. Again, another shot from the front of the property on October 3rd. The property was posted on November 14th, 2019 with the tarp still in place. And that's all I have.
Second motion.
Second motion. I move to enter an order requiring the respondent to correct the violations on or before November 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation. For each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion carries.
Good luck.
Thank you, sir.
Yep.
Thank you for coming in. Okay. Case 40-20, 1510 South Fort Harrison Land Trust, John A. Pantelis, trustee at 1501 South Fort Harrison Avenue, in violation of code for abandoned building, door and window openings, inoperative vehicle, and issue an order with compliance deadline and fine if compliance is not met.
Good afternoon. I'd like to represent my son, although he's here. He's a little emotional.
Okay.
Okay, I'm Florence Pantelis' mother. The property was originally mine, but I'm 88. So when I turned 78, I said, I don't know where I'm going with this. I put it in my son's name. And it's 1501.
Okay,
1501. Okay, now,
Not 1510.
it's 1501 South Fort Harrison.
we knew that, but 1510 is the, never mind.
Yeah, we have 1510 on the,
Land
Yes,
trust.
but then you have 1501 down below.
Right.
Yes, we do.
okay, but.
Yes, yes.
It's just a script, there's zero on there.
But it's 1501 South Fort Harrison.
Okay.
Which one has the problem?
No, it's only one building,
Oh, it's
sir.
only one- Okay, I'm with you now.
He made a
Only
typo
one
error.
building.
Yeah,
Scrivener's error.
gotcha.
Okay, now,
It's Nicole's fault.
according to this,
Madam Chairman, we need to admit or deny.
I beg your pardon?
Do you admit or deny?
Oh, no, I deny.
You deny, okay.
I deny. All of the violations that are presented here are now in compliance, as Mr. Cashman knows.
Okay. If you'll have a seat, we'll call him up and we can find that out, okay?
Yes, however, I was told that I was here because we didn't have the utilities turned on. And they're not even listed in the compliance, in the violation.
I think a building is considered abandoned if there's no utilities, isn't that right?
For a period of 6 months or greater, yes.
Abandoned, the building was never abandoned. I use it to store my own and my son's private property. I use it as a storage facility.
We understand that.
Yes, sir.
If you just have a seat,
Yes.
let me talk to the inspector.
Yes. Yes.
All right, good afternoon,
Hi.
Board. My name is Daniel Kasman, I'm Code Enforcement Inspector for the City of Clearwater. This is for case number 40-2020 for 1501 South Fort Harrison Avenue. There were 3 violations here. Code Section 3-1503B6 for an operative vehicle, which has come into compliance, which will be declaration. Code Section -31502C1, 3-1502D3 for door and window openings, window maintenance. There was a broken front window, it's been taken care of. That's also going to be a declaration. But the last issue is that it's in a current state of abandonment due to code violations, and utilities have not been on since about 2014. And there's no use for the building, nothing is going on. It hasn't had an active business in almost 20 years. Yeah. This is just for the postings page. The vehicle was posted on 10/30/2019. The notice of violation was sent on 10/30/2019, and then again on 12/3/2019. I have multiple different compliance dates for the different violations. 11/13 for the vehicle, 11/21/19 for the window, and 11/31 for the abandoned building. And then an additional compliance date of 12/13 because I didn't get any recognition of the mail being obtained. And then the notice of hearing had to be posted on Valentine's Day, 2/14/2020. This is the building in question. October 30th is when I first went by and noticed. Front window was broken. There was a big shard of glass just sitting in the frame. Was wondering what was going on. Took a look around the back. There was a hot tub, a vehicle, and a boat in the rear of the property. There was no tag on the trailer. There was no license plate on the trailer. The right tire was deflated. That was again on October 30th. The vehicle was posted on 10/30. The instructions saying compliance can be met by obtaining and displaying a current tag and license for this vehicle and inflating the tires. The other white vehicle was posted, but it was removed very quickly. This is just a better shot of the front window, broken shards in the frame. This is the picture of the utilities, 1501 South Fort Harrison, water cutoff date November 6th of 2014. So the property hasn't had utilities in 6 years.
What about electricity?
I called up with Duke and they said there's no active service.
Okay.
So I went back on 11/15 after the compliance date. There still is no license on the trailer or the boat. Back on 11/25, still no license or trailer on the trailer. 11/25 for the window, past the compliance date. The window was still broken. Went back on 12/03, tires still flat in the boat. this was the affidavit of posting for all three of the violations. Did post the property for the hot tub issue, but it was taken care of because it was full of brackish water, but it was taken away. Again, 1203, the window was still broken. Back at 1209, still nothing done with the boat. And then again at 1216, license plate was applied on the boat itself, so it is current. Front window is still broken at 1223. The utilities, I just went into the history of the utilities. Looks like it was just cut off, and then the water, it was just written as a write-off for some other charges. 1223, the boat was current, but the issue was that the tire was still flat, and that was part of the instructions on the posting. Take care of it. It was the same instructions that were on the notice of violation. It didn't get a green card back from, but it was posted at the door on the front of the property. But went back on the 5th of February, and the window was fixed, so that was one issue taken care of. And the boat trailer still had a current tag. This was on the 14th. This is the notice of hearing, because there was no green card gotten back for the hearing. Went back on the 24th, the tire is fixed. It has a current tag, the trailer, it's good. It's declaration of violation. But the utilities are still not current, and there's no current BTR for any sort of use for the property. Thank you.
Inspector, if I may, there's 3 violations, 2 of them are taken care of.
2 of them are taken care of.
The vehicle?
The vehicle and the front window being broken are both taken care of. I would like just to read out the definition of abandoned building.
Okay.
Any building which are abandoned, boarded up, partially destroyed, or left for a period of 6 months in a state of partial construction or without utilities are declared to be a public nuisance. And also abandoned building from the definition in section 8-102. Abandoned building means a building or structure that is deserted by the owner and left unsecured or that is not maintained. Evidence of desertion and lack of maintenance shall include, but not be limited to, unaddressed code violations, lack of required building permits or certificate of occupancy, lack of business tax receipt, and lack of active utilities. That's all I have.
So I'll do a declaration on the 2.
Make sure that we have to be here for the respondent as to the declarations.
Good afternoon, panel. My name is John Pantelis, spelled P as in Peter, A-N, T as in Tom, E-L-E-S. I'm Mr. Bueno. I've been an outstanding citizen in this town since 1974. The trailer, the boat trailer, I live right on the corner of Woodlawn and Fort House and Gwynn, my building. The boat trailer license plate was stolen. It was good for 2 years and it was stolen. Now, as far as the car that was brought there, one of these code enforcers closed down a body shop at the corner of Myrtle and Bel Air Road. I don't know which one it is, but they know who they are. My car, that little 1979 Toyota Supra, was having body work done there. He went out of business because the code enforcers shut him down. Little did I know, because he granted me that he would tow my car to his new body shop to repair at his new location. But he brought it and towed it to my place. 2 days after the fact, I went there and saw the car, and this gentleman was not, I'm telling you the truth and nothing but the truth. This gentleman was not there. There was another probation officer there, code enforcer there, with a black police officer. And I moved that car 1 hour later. The license plate was stolen off the boat. And Mr. Tennis, who knows me, Tunis, knows me very well. We shared tears together. Because my dad ran Grand Central Station in Manhattan and worked with the police department, and so did Mr. Tunis. So when somebody knew, and I introduced myself right away to Mr. Pislyak right away when I got his number, because I don't like to come somewhere and not know anybody. Because they have to know what type of individual I am. I'm an outstanding citizen of this town. I have 2 beautiful projects that were done in my name. Right next to my property was the Dollhouse Post Office. I don't know if you guys are familiar, they've been there for over 30 years. And we've owned our property for 40 years. And the ladies used to come into the post office and turn in, coming up from Largo or Seminole, Bel Air, turn and come in. But when they were leaving, they had a hard time crossing 2 lanes of northbound traffic to go south. I called up the state of Florida, since Fort Harrison, right in front of my building is a state road. I said, please come out here, look at these ladies. They're having a hard time crossing. There's near accidents every day. They came out and said, Johnny, you're 100% right. Can we use your property as a staging area? And I said, certainly. So from Bel Air Road, north, they made the merger. So it used to be 2 lanes in front of my place. There's now 1 lane. And I did that for the city of Clearwater. And I also did the Gabion project in Plum Elementary at Magnolia and Brookside with my name on it for the city of Clearwater. The Gabions were the lobster pots with rocks in it that was stopping the land from deteriorating and eroding. So what this gentleman is saying here is 100% wrong. And that's what I want. That's why I'm here with my mother today. I conformed right away. You know how the window was broken? I let the kids there skateboard. I'm not going to say no. I'm a ball player. I trained Matt Geiger and Crawford Kirk, 2 huge superstars in this town. The kids skateboarded there. They were doing a trick, and the board came up and went through the wall. I'm not going to tell kids to get off my property. I'm not going to tell homeless people to come off my property. It's not my nature. Okay, but I let the kids skateboard there and they broke the window. So be it, I fixed the window.
Hey, Johnny?
Yes, sir.
Listen, thank you very much. I remember the dollhouse, you used to sell carpeting out of there.
I didn't own the dollhouse, they were right next to me.
Or the dock next to you, right?
I just did the deed for the women because they were hard on hard. There was 3 or 4 near misses every day. Because people were coming around that corner when it's too late. You guys know what I'm talking about.
You're in compliance on 2 of the violations.
And Mr. Tunis, God bless him, told me, Johnny, the only thing I want you to do here 3 years before I met this gentleman was please put the 1501 in your front door, because I didn't have any numbers on the door. I said, yes, sir, please put the 1501 in the front door and 1501 for the back door in case there's an emergency, they know your address. He never, and one of the ladies here came before he did, and she said, how about the jacuzzi? And he said, don't worry about it. Everything's fine. The jacuzzi is fine. And when he said something about the jacuzzi, I went there 3 days later, and it took me 8 hours to disassemble it and took it off the property. But the jacuzzi was on that property for a good 4 years, 4 years or so before Mr. Tunis came to my property.
Hey, Johnny, listen,
yes, sir.
No disrespect.
Yes, sir.
We have a ton of cases.
Yes, sir.
So listen.
I just want the truth to be told. I'm here to tell the truth and the whole truth and nothing but the truth. I'm one of those type of guys.
We're addressing the abandoned building, sir.
Yes, sir.
How about the abandoned building?
Right now it is used for nothing but storage. I go to a lot of auctions, and it is full of beautiful furniture in there.
But you know that after a building...
No, I didn't know any of that. Because I go there 2 or 3 times a day, or 2 or 3 times a week.
Right, there's no utilities hooked up to it.
But there's never has been.
No, but I'm just citing the law, the code to you. If a building...
Well, why wasn't I told about the code 40 years ago, sir?
It's out of compliance. So what the city wants you to do is comply, or...
Comply with what? It's my building. You're going to tell me, what am I complying? I'm there in the daytime. Why would I need electricity? I don't use the bathroom there. What would I need running water for? And another thing, by the way, I mow my lawn there twice a week in the summertime. And across the street from me is your property. And you know what? It never gets done.
Johnny...
I go across... Okay, I'm listening to you, but please listen to hear me out.
Well, we've heard enough, I think. We've heard enough.
You've heard enough of the truth, correct?
Yes, sir.
Yeah, nothing but the truth, so help me God.
We've heard your side.
And thank you for that.
Thank you, Mr. Carino.
But what we want is compliance.
What is the compliance for?
If you give us a minute, we're going to tell you.
Yes, sir.
Does this lady have anything else to say?
My mother's beautiful, 5-star. She just came here because she knows what type of person I am.
I agree with you. But
But nobody's gonna write me up and degrade me, please believe that.
This is not-
Nobody's gonna leave love letters on my window.
Sir, you need to calm down and let your mother say something.
Okay.
We're not here to degrade.
I would like to know why we need to have the water and the electricity turned on. When
Wow,
these-
you're
yes,
talking. Right, so my suggestion would be to communicate with the city to find out what you need to do to comply.
That's why we're here.
Exactly,
Yes, sir.
that's what I was trying to tell Johnny.
Well, that's why I'm here.
Yes.
So let us go forward. Let us go forward.
May I ask a question? Is it possible to continue to have that building, which is not abandoned? We have a little tree, we have the grass, we painted it again about 4 years ago, okay? And when it was staged with the city doing their work, they ruined my blacktop. They're the ones that ruined it with their heavy machinery, and we could never get a response.
Ma'am, why were the utilities turned off so many years ago?
Why?
Mhm.
Because I wasn't using the building anymore except to store my personal property and his property.
Ma'am, may I tell you why? Because I know that building.
Yes?
Okay, and that building used to be a tires place. I used to do business with them. And that, before you
Just
got
a
in,
minute.
was their
That
tires
building
place.
has been
And
mine
since they
since
closed down, there's
1992.
been nothing there.
Okay, hold on for a second, Mr. Engel, please, sir. You opened up a beautiful can of worms that I told Dan to
I love
do.
you.
You know why that time place is not there anymore,
It
sir?
doesn't matter.
I threw them out because they were
It
co-field.
doesn't matter.
Okay, so what are you saying? It was our property though.
It doesn't matter.
Okay.
Since they've left, there's
I'm
been
gonna call a
nothing going
stop
on
here.
Listen, we had kings.
Pardon me?
First of all,
Everything is the truth, Mr. Johnson. We threw out a person that was paying us every month.
I don't know where-
We believe you, we're just trying to get down to the facts of this.
Yeah, I tell you, but he brought up a topic, so I had to tell him the truth.
So, it seems to me that there's some misunderstanding on your part regarding why you have to have utilities.
Yes.
So, we're gonna make a motion, and there's gonna be time,
yes,
okay, for you to comply. And you should use that time to talk to the city to see what you need to do to come in. Maybe there's a different classification for that building that could be applied that deals with utilities. I don't know. But the thing is, the code requires for a building to be considered not abandoned by having water and electricity. Okay?
yes.
Because if they say there's no water being used, and there's no electricity being used, there's nobody there. Okay, well, you're using it as storage. Understand why maybe you don't need it, but you need to work that out with them. We cannot resolve it here today.
Mr. Braxton,
Yes.
wouldn't he have told me that?
Well, it was
kind of like he told me that.
I haven't seen those papers, but there's a good chance that it was in the mailings that you received.
So I'll make a
And there's a lot
declaration.
of verbiage, there's a lot of stuff to read,
Yes, sir.
but that it probably was in there. But the thing is,
But Mr. Tunis never said anything about that.
yeah, well.
Nobody ever said anything about that
And as
before.
you said, sir, that was 4 years ago, and we're kind of here today, and here's the thing.
So we're gonna
And
change
we
every
really
4
appreciate
years
the fact
on what
that
we
you've
do?
been proactive in getting all the other things corrected, but you need to get this resolved and use this time to your advantage.
I'm going to make a declaration on the 2 violations that you've corrected,
Yes, sir.
and then we'll discuss the issue of the abandoned building.
Yes, sir. Can you
Okay.
please tell me what I corrected, sir?
Exactly. What you corrected, you
Yes, sir.
corrected the vehicle
And the glass.
and the broken window.
Yes.
Okay, what I got to say about the vehicle was, please, the
We've
vehicle
already
should
heard
have
enough.
never been there, and it was done in that vehicle, one of the girls was there, I don't know which one.
Johnny,
Yes,
listen,
sir.
you're out of order.
You're in compliance.
Sorry, sir.
You're out of order. You got to just hush for a minute.
Yes, sir.
Let us get this part out of the way, and then we'll talk about the abandoned.
Yes, sir.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The 2 violations, the window and the vehicle.
Yes.
You did a good job. Referred to in the affidavit in this case. The violations were corrected prior to today's hearing and to enter an order that no fine be imposed. If the respondent repeats the violations, because there is 2, the board may order a fine of up to $500 for each day the violations continue to exist.
Second.
All in favor?
Aye.
Motion carries.
So now we need to talk about the abandoned building.
What's the recommendation?
If I might go up and show the recommendation.
If I may say something.
No, ma'am, have a seat in the front row, please. Let him speak now. Thank you.
Our recommendations for case number 40-2020, two of the violations, inoperative vehicle doors and windows, which are a declaration. For the remaining violation of abandoned building, requesting compliance on or before March 26th of 2020, or a fine of $250 per day for each day the violation continues to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. My recommendation for the abandoned building violation is to have them comply with all violations of the property, which they have done, the other two violations, turn on the utilities, and having the building occupied, which in this case would mean obtaining a business tax receipt to have some sort of use for the building.
So, I have a question. Why the fine of that magnitude?
I was told by, I forget exactly who it was, but I was told that because it is an income property, it is not a property that's not homesteaded, that it was asked to put that amount. I can lower it if you wish.
No, that's what we can do that.
Okay.
Okay. It seems pretty high for me.
Yeah, and
You know,
the time,
because
too.
given the response on the other issues that they've been resolved, that people are working towards getting this to a conclusion.
Right. Exactly.
Well, to help maybe slow it down from keeping rolling along and getting, while we're waiting for that, what if we just lower that amount now and have it done by a date and be done?
Let's do it.
Right, let's do it. All right.
Okay. Can I have a second motion?
What's the date that we have on that?
The date was
March
March
26th
26th of 2020.
Do we have a second on that declaration?
Yes.
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 We did, okay.
We did, yeah, I made it.
Okay, so we,
I'm sorry, I just want to correct the record. The gentleman is upon, does not need to obtain a BTR. All they need to do is turn the utilities on, and then the building will not be abandoned.
Make it real simple.
And sir, I don't mean to speak directly to him, but if I may, literally, all we're asking you to do is turn the utilities on. That's it.
and
And
what,
the reason for that is because, as the inspector said, when there's other violations on the property which you're permitted to, the broken window, the car, and everything, and the utilities are off, it's determined to be abandoned under the law. If you bring it out of its abandoned spot by correcting violations, which you have.
In an instant, Mr. Fuino, it's never been abandoned. I go there maybe two
I
times a day,
understand
sir.
you don't think it's abandoned, but the law considers it to be abandoned by not being occupied.
Because it's not open for business, is that why it's?
It doesn't have to be open for business, that's why I'm saying you don't need to get a business tax. All I'm saying is you need to turn utilities on, that's it.
And what is the reason for that, please?
So you don't trip over your feet in the dark when you're in there doing something.
Nobody's ever in there after 1 o'clock in the afternoon, sweetheart. Nobody.
The reason is that's what the code requires.
But why didn't Mr. Tennis tell me that? Why didn't anybody else tell me that in all these years?
Sir,
We
I don't
can't
know
address
why, but
that.
that's what the
We
code
don't know.
requires, and
We
that's
don't
what the
know.
board has to follow.
Mr. Press, I acted right away on these things. The car was never supposed to be there, and I did it the next day, so I want you to know that.
We understand
You
that.
say all these things and acted right away.
Yes, but anyway, what we're asking you to do now is get the utilities turned on and your problem will go away.
Okay.
Just that
Okay.
simple.
That's
We
what
do it on
it
the
is.
minimum.
Tell 'em, Mom.
In other words, whatever the minimum.
The minimum.
We're not gonna use the
That's
word,
right.
and we're not gonna use the water. We don't have to. We use it only as
Okay.
I know, but then.
Do it the least expensive way and just do it.
Can I have a motion?
Did you say something?
Okay, I moved in an order requiring the respondent to correct the violations on or before March 26, 2020. Respondent does not comply by that day, the board may order a fine of $150 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
second.
Wait.
Are you gonna say?
Wait.
Yeah,
We did not receive a first motion
right.
on this issue. We need the first motion first and then the second.
Okay, I'll make the first motion. This is on the abandoned building. No, we did the declaration.
We did the declaration, so we didn't do this.
And that was seconded, so we need a first.
Yes.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
We all said.
All in favor?
Aye.
Motion carries. Okay.
So is his second still stand? Even though we did it
The
backwards?
second motion, no, let's redo it, unfortunately.
I move to enter an order requiring the respondent to correct the violation on or before March 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. Fines and fees remain unpaid 3 months after such lien is filed. The city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor?
Aye.
Motion.
Could I ask you one other question, please?
Yes.
Abandoned. Leaving a place empty without intending to return. And that is that's a perfect definition of the word, okay? I attend that place 2 or 3 times a
It
day.
doesn't matter.
It is not abandoned, it's my big.
We agree with you, it's the
You're
code
out of
that's
order,
written
sir.
otherwise.
I'm trying to be
No,
right.
but the case is over.
It's not a
Need to move
storage
on.
building, sir.
Okay, I want to be fair.
Johnny, good luck to you. You know what you gotta do.
Thank you.
And I don't want him bothering me anymore, please.
However, Mr. Collins, if you're familiar with that area, there are a lot of street people,
Who knows that?
and they used to turn my water on and take a bath.
Absolutely.
Ma'am, as the board, we have blinders per case. I understand and I hear you,
Unfortunately.
and I hope that gets out there, but I can't help you.
Our homeless people.
I understand.
Okay, thanks.
Thank you, ma'am.
Case 41-20, MAD Corporation at 1475 South Michigan Avenue. In violation of code for fences and issue an order with the compliance deadline and fine if compliance is not met.
This is going to be a declaration.
Okay. Can I have that?
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist. Need a second.
Second. I can't second.
Second.
Okay, second.
All in favor?
Aye.
Motion carries.
We're getting there.
I was gonna third.
Okay. Case 43-20, right. Benjamin Rivas Sr. at 1450 Court Street in violation of code for roof maintenance and issue an order with the compliance deadline and fine if compliance is not met. Is he here?
1450 court?
4.19.
He's not here?
No, it doesn't look like it.
Okay. I have a first motion.
Yes. Not a declaration?
No, this one, it's still in violation, but probably will be fixed very soon. They already obtained a building permit to fix the roof, and they're near completion.
Okay, I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay.
So for this case, 1450 Court Street, this is case 43-2020. Requesting compliance on or before March 26th of 2020, or a fine of $150 per day per violation for each day the violation continues to exist. We're asking the board to authorize the following. After 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And compliance can be met for the roof maintenance by repairing the holes in the roof and the soffit, the south side of the southern building of the property, and removing any loose shingles from the roof. Do you want to see any photos from this one, or?
No.
No. Yeah.
We're okay. Second motion?
Yep.
I move to enter an order requiring the respondent to correct the violations on or before March 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Aye. Motion carries. Okay. Case 44-20, 5 respondents. Catherine E. Vankensteren at 1225 South Belcher Road in violation of code for RV parking and issue an order with compliance deadline and fine if compliance is not met.
This one also did that direction.
Good.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Aye. Motion carries. Okay, 45-20, Chestnut and Myrtle LLC at 708 Chestnut Street in violation of code for exterior surfaces, door and window openings, and abandoned building, and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
Hello,
Hi.
I'm Ray Casano. I live at 628 Cleveland Street,
Uh-huh.
Suite 1501, downtown Clearwater.
Could you spell your last name, please?
Cassano. I usually sit here and he usually sits there. We're both in the downtown development board.
Okay.
And our purpose is to enhance the downtown.
All right.
So, do you admit or deny the allegations?
Well, I got the violations several months ago. It wasn't you though, it was the.
Sherry Hollifield.
Sherry, yes. And I called Sherry and I said, Sherry, you know, that's gotta be the ugliest, worst building downtown Clearwater. And people were driving into the building, I mean, I swear, it's amazing. And we've been boarding it up. So she said, I said, well, we're gonna fix the building. So she said, don't worry about it if you're gonna fix the building. So this is what's happened. We went in front of the,
Sir, we need to admit or deny.
oh, well, I guess I have to admit that there was some violation, Jim.
Okay. Thank you for that. We're gonna make a motion, and then we'll bring it back.
Move on then.
Well, Nick,
Sure.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Aye. Motion carries. Okay, now.
Sherry did say, don't worry about it as long as we're gonna fix the building, so I guess I'm in violation. Now, we had to sit in front of 17 department heads of the city. We did that. It took quite a while to get that done. You know, the water runoff, the sprinklers, the fire, the police, the whole thing.
With the plan already done, with the
Yeah.
architect.
So we got that done. We had to go to an architect and find out how to do this building. They won't let us put the parking in the front, so we gotta keep part of the building and then extend a new building out to the sidewalk. So there's no sense of fixing those windows because it's gonna be in the interior part of the building. I do have a drawing if I can put it down here.
Okay.
Yeah,
sure.
okay. You guys know what the old building looks like, right?
No, I can't think where it is. That's-
Oh.
I think I have.
Got a picture, stick it up there because,
It's the ugliest in Clearwater.
yeah, it's definitely the ugliest.
That's pretty ugly.
It's the new Walgreens. It's the new Walgreens, they own everything but this corner. I think he's.
And that's been there for a long
Madam
time.
Chairman, excuse me.
30 years.
Should we be hearing from the inspector first before his case?
Well, sort of.
Yeah, that's
But
the
they
way
were
it needs
here.
to go.
It's up to the
We're out of order here, and we need to hear from Mr. Campbell.
Just have
However,
to
before we should-
Sure, no problem.
whatever you like.
We were understanding, we let Mr. Katz come up.
No, over here on Chestnut. Yeah, they're on the
Yes, of
corner.
course.
Good afternoon again, Daniel Jasmine for
Code enforcement inspector for the city of Clearwater. This is for 708 Chestnut Street, case number 45-2020. This is a case that took over from Inspector Hollifield. There were 3 violations here. Code section 3-1502C1 and 3-1502C3 for door and window openings and window maintenance. 3-1502B for exterior surfaces, and code section 3-1503A, B1, B2, B3, B9 for abandoned building, nuisance, attractive nuisance, other nuisance condition. Her notice of violation was sent out on 07/17 of 2019 with a compliance date of 08/2019, and the certified mail receipt she received back was on 07/24 of 2019. So they got the violations. This is the building that they're talking about. It is on the corner of Myrtle and,
Chestnut.
yeah, Chestnut, right there. Yeah, it's in some rough shape. This was taken on November 26th, 2019. The issues are some of the windows and doors are being boarded up. They've just been sealed off. The utilities have been off since 2002, so it's been about 18 years since they had running water or electric. Just some exterior, well, there's more than some, but there's exterior surface issues, chipping and peeling paint. Electric box is not secured. Try to get out some shoestring. I went back on February 5th, 2020, and there's still no real change, except now it's been boarded up even more.
What is the city is seeking?
We're seeking for them to fix the exterior surface issues, onboard all their windows, and turn on their utilities.
So they can tear it down?
I wasn't aware that there were any plans in place for any tear down.
Okay, well, it's okay, there's only one planning and development department in this city, and it shows how it works sometimes. Thank you.
That's your suggestion, sir. You don't know that.
Have
You're
they
guessing
been in compliance, or is it still?
No, it's all still
pending?
not compliance.
Right.
So I went back on the 11th, still no real change. Issues around the exterior of the building. No use, still abandoned. I went back on the 24th. Just, the whole building needs some work, and someone set up residence in one of the alcoves on the building.
Let me ask one question. Did you notice what you would call serious safety issues?
I talked to the building inspector, Cantrell, about the electric box, but I don't think there was any issue because there's no electric running to the building.
Okay, I mean, that would concern me.
I guess the only other issue is just people living on the property.
Yes.
Yeah.
People living on the property?
Yeah. There's a couple who was living in the outside the building, living in the alcoves on the building.
I can back him up on that. I live across the street from this property, and they do live on the property.
How about police reports?
I haven't yet seen any official ones. I haven't looked in the official ones. I just have another case open for lot clearing on the property. Two of the palm trees in the back are covered in garbage, and there's, like I said, there's a bunch of debris where the people are living at.
Okay. Gentlemen? What are your plans? What are your immediate plans?
Well, we've hired Mr. Genetti, Mark Genetti, the architect. He drew this diagram down here. The only thing that's delaying the project at the moment is going in front of the city for an incentive program, whether we go 2 stories or 3. And we haven't had the decision yet. It's going to be here next month. But I still contacted Mr. Genetti and said, look, let's get some of the demolition started. So he's in the process right now of doing that. We have got a loan from Valley Bank of $750,000. Mr. Amrani has produced $750,000. So we are in the process of getting it done. Like I said, we sat in front of the 17 boards and got our recommendations. The architect agreed and has got the runoff all figured out. We're going to add 17 parking spaces. We're going to add 14 apartments and 4 new stores. We're only keeping a part of the old building because we're going to expand out to the sidewalk. The part that's bad is going to be tore down, and that's going to be a parking lot. So we're going to put $2.9 million in that building. I think we're going to take one of the worst buildings downtown, if not the worst. We're going to make it one of the better ones. It's the second busiest corner downtown, so people that don't live here leave the beach and they see that. Now they're going to see that. So it's our purpose of being on the Downtown Development Board to enhance downtown, and that's what we've been doing. You'll find there's no problem with me on violations, there's no problem with me at the law.
So
What is your time frame?
Doing this?
It's in progress.
Well, when do you know, let's just say, you said you're gonna tear part of it down. When do you think you're gonna do that?
Well, we are going to be here in March to determine how much of the incentive we're going to get to determine whether it's 7 apartments or 14 apartments above.
Okay, so you'll have an answer then From that point forward, how much
Oh,
longer do you think?
immediately. We want this done by the end of the year.
So you would think that
But
you'd have.
but I'm not a contractor, so I don't know how that's thinking.
So do you think by May 1st, you would have commenced doing something physically?
Yes,
taking it down?
yes, May or June 1st. A little background here.
June 1st, okay.
I developed Station Square, the 128 condominiums. The city needed it done for that new project. They came to me and I did it. So I am experienced, and I have made downtown much nicer because of it. And I live on top of it. So I have skin in the game, and I do want this building gone. I do want
It's
the.
so attractive, I don't know why you'd want that.
So you know now you're on the city's radar. You know, you remind me of.
I sit there and he sits there.
I was in business all my life, small business, and you remind me of the customers that used to dangle a carrot in front of me.
Yeah.
Hey, you know, you do this job for nothing, we'll give you these jobs, you know?
Yeah.
And I quickly learned nothing times nothing times nothing is still
nothing.
nothing. So we need a commitment from you. I mean, you don't want to come back before us as a repeat.
No, we will not. I have no history of being in front of you guys. I mean.
We need
yeah.
some more solid
I think
answers
we
from
should
you.
ask the city what they want to see happen, and then we can. figure
Yeah,
out
Mike, I'm
more
interested
time.
in what.
What do you want
What
done?
does the city want to see happen?
Well, go ahead.
So, we decided December 31st, 2020.
December 31st?
Yeah.
You'll see long before.
Whoa.
Well, first of all.
Finished or started?
Oh, God.
We'll finish, but, I mean, and I know the agreement that you're talking about.
Yeah.
Because I'm the CRA attorney, it's not with the city, it's with the redevelopment agency.
Right.
And it probably won't even happen next month, or won't, we'll just bring it up next month, and if any agreement would be reached with the April. Right, because that's the way we do it, and I don't want to get too far upstream here. So, why don't, and I know you don't have a building permit, but you've talked to the building division, correct?
We have all 17 departments.
Okay. And then it's just a matter of, maybe we should start some benchmarks about, when do you think the project would be completed?
I think it's possible by the end of March of next year. So it'd be about 13 months. We would start probably within 120 days, but again, that's out of our control. But we wanted as much as you want that building gone and a new one there.
Wait, believe me, but you wrote this down. If I may say, if you don't see any major work being done on this property by December.
Why don't the gentleman, I'm sorry, I didn't mean to interrupt. Inspector, why don't you go up and explain what you want done, and then we can talk about if that's even something that you're gonna do, or you're gonna do it in conjunction with the construction. So, go up there and say what you want to do.
He's already doing
Do
this.
tree stuff, I don't know.
Well, the recommendation was going to be for all the issues with boarded up windows, exterior surfaces, and the abandoned issues was going to be a month's time. I wasn't aware of any of this redevelopment, didn't look like anything was going on in the building, and I didn't see anything in the system pertaining to any building permits from them. I would say if you want to give me contact information and keep me updated on what's going on, or what will be going on.
Absolutely.
Seeing a permit.
I think we would go by that. That'd be boarded up.
If the board wants to, you can pick a date to just have this come back for an update. And if you want to pick a date for, say, demolition, demolition by June 1st, you want an update. And then after that, you'll have more understanding of really, once it's demolished, as to what their time period is.
So you intend, sir, you intend to demolish existing structure?
No.
Or
Most of it.
There's one part of the building that's.
You have to be up here to.
Yeah,
Oh.
I just need you up here, thank you.
The corner, we cannot use the parking in front anymore. So we're gonna take the existing two-story part and double it with a new two-story up to the sidewalk. The Quonset hut, the nasty part, will be tore down for the parking lot.
That's that thing in back?
Well, it's like, if you look at it, it's like a Quonset hut. It's-
Right.
Yeah, it's a rounded roof, that's gonna be gone. So, the two-story part, that doesn't look as bad as the rest of it, we're gonna double that. the old two-story and a new two-story. So the estimate from Genetti is $2.9 million.
You're talking about side by side, two-story side by side.
Yeah, the old one and a new one. So we're probably gonna gut it down to the foundation and then put the new one on.
So you're gonna segue, once you tear it down, you're gonna segue right away into building.
Yeah, oh yeah.
Okay. So the thing is, the problem is never really gonna go away.
This will be like a 1100 building on a
Oh,
small
it's like
scale.
that Burgess Meat Market.
My
No,
problem with
no,
this
no.
is,
You gotta admit, Station Square went up pretty fast. I'm not,
Talk about this.
my problem with this is you were supposed to be in compliance in August of last year.
Sherry said,
Don't worry about it.
don't worry about it.
So
She said, as long as you're gonna fix the building, don't worry about it.
well, this is that carrot again.
We would recommend that you go ahead and set it for a status, probably your June meeting, which is June 24th. Then we can bring it back before you'll have a status, have a better understanding of what's going on, and then we can look at other dates from
How
that
does that
time period
sit?
for total compliance.
Thank you. Well, are you talking about just moving this whole case to June
For a status hearing.
For a status report, yes.
for a status report, but not deal with any fines or?
Not dealing with any fines until you're comfortable or uncomfortable with what is progressing on the property.
Yeah, we've had these before.
How does that sound to you?
That sounds fair, and keep in mind, I do not want to be like these other guys. I want this thing done March 31st of next year. People in it, renting, downtown.
Madam Chair?
Yes.
Yes.
I'll make a motion.
Sure.
Okay, I move that in case 45-20 regarding the property in Chestnut and Myrtle, 708 Chestnut Street, be moved and heard from on June 24th, a status report with the condition of the building and the progress towards constructing a new building being reported.
You'll send me your emails, it's communication.
All in favor?
Aye.
Motion
That's
carries.
All right, good luck, guys.
You'll
Good
find me
luck.
easy to work with.
We'll see you in June.
Okay, thank you so much, appreciate it. No, you'll see some work done by then, I promise.
Thank you.
Thank you.
Are we ready? Case 4620. Trust number 1462, Land Trust Service Corp. Trustee at 1462 Franklin Street in violation of code for exterior surfaces, door and window openings, exterior storage, and an issue with compliance deadline and fine if compliance is not met. Yes, sir.
Yeah, I'm Don Ingracia, I'm the owner of the property.
Sir, would you give me your name again?
Ingracia, I-N-G-R-A-S as in Sam, S-I-A.
Your first name?
Don.
Thank you.
Okay, sir. Do you admit or deny?
I admit, but like this gentleman here, I had Sherry, and I was in a major motorcycle accident when I got written up. So she told me the same thing, when you're
Don't
up and
worry about
healthy.
We're gonna find Sherry. No.
Yeah, when you're up and healthy, finish it, which I told them in the winter time, it'll be all painted, which they'll admit it was. So, here we are. Everything's been brought up,
All right,
except for the
first
bucket
motion,
that's still there.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion carries. Okay. If you'll have a seat, then we'll call you back up here.
So for two of the violations, they have come into compliance for the doors and windows and exterior surfaces. So those will just be declarations.
Okay.
Doors, windows.
Doors and windows,
Exterior.
doors and windows that were in some bad shape, they were taken care of. And the exterior surfaces were, the whole place has been repainted, taken care of.
So it's exterior storage is what we're doing?
Exterior storage is still in violation, but it was mostly cleaned up, just a little bit more to go.
Okay.
It'll be in compliance.
Doors and windows is done.
Yeah, doors and windows are done, the exterior surfaces are done. So, we're just requesting compliance on before March 26, 2020 for exterior storage.
Okay.
For a fine of $150 per day for violation, for each day the violation continues to exist. We're asking the board to authorize the following: after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Compliance for the outdoor storage by storing all construction materials properly and removing all items not meant for outdoor use from the property. Would you guys like to see any photos or?
I'll make a motion for the declaration.
Want to go ahead or?
Sure, we can watch and listen.
Yeah, go ahead.
This was on November 6th, went out to look at the property, 1462. It's got a few units that go long ways into the property, so they're deeper on the property. There's some painting, peeling paint, a bunch of outdoor storage, toilets, just random materials, weight set, needed cleaning up, needed some work. Sherry already sent the notices of violation and you already received a green card from them. But there's also a stop work order in the property because there's work being done without a permit, but he's come to compliance and gotten a permit through the building department. Like I said, just outdoor storage, exterior surface issues need to be cleaned up. Went back in December and there were still issues. Back in January, some progress had been made, but there were still a lot of items being stored outside. Some painting had been done. It was looking better. This building was still in a little bit of rough shape. Went back on the 21st of February, and that building has been painted. That building has been painted. There's just a little bit of storage left. It's got to be cleaned up, and then that will be in compliance as well. Shed just needed some work. Went back on the 25th. The outdoor storage is still there, and then the shed has been painting. So the property has increased. The property looks way better than it was.
Way better. So,
Robert, you going to do the declaration?
I will. I move to find the respondent was in violation of the code with reference, as referred to in the affidavit, regarding doors and windows and exterior surfaces. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
all in favor? Motion carries. Okay,
We got the
second one, exterior storage.
Want me to make it, or do you want to talk ahead?
Don, will you be able to have the exterior storage cleaned up?
Yes, well, obviously the exterior storage was the stuff that needed to be there to
Right.
work on the buildings.
Right.
Yes,
By
I mean,
March
down to
26th?
paint buckets, because we just finished painting, you know, so it's, and a couple ladders, I mean, I'm sorry, the guy can't hump the ladders back and forth.
You're okay with the 26th?
Yeah, we're good.
Okay, good. You've done a great job
Yeah,
there.
Well, I told Sherry as soon as I'm back up and running, she's like, yeah, no problem, and then I got the new guys, so.
We're going to talk to Sharon.
You better tell her she ain't here no more, so. I said as soon as the, what?
One question for you. So, how many tenants do you have there?
There's 4 units, it's only 4
units.
units, yeah. They're little.
Are they with you on the same thing regarding outdoor storage? Because they can contribute also.
Well, the one tenant was his workbench, and so he was working out and actually doing all the rotted wood that Sherry was complaining about. So she wasn't really upset about the weight bench and everything. She just said, get all the rotted wood replaced, which I did, all the window trim. And one of the tenants smashed the window, one of the old tenants that I evicted. So when I replaced the window, then they stopped work order. So I'm on a stop work order, but yet you want me to fix the violation. So I was kind of in like a catch-22. Then the contractor that replaced the window had to upgrade his paperwork for the city of Clearwater, because it doesn't really do much work in the city of Clearwater. So that took 2 months. So it was a whole
You did a good job.
rolling.
Okay, can I have a second?
I move to enter an order requiring the respondent to correct the violation on or before March 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Do you want to make it exterior
Oh,
storage?
that was for the exterior storage.
Yeah,
The rest is all in compliance.
Yeah, the rest of it's all done.
Yes, sir.
Second.
All in favor?
Aye. Good job.
All right, thanks, guys.
Motion carries.
Thank you.
Sorry you had to wait so long.
I wanted to hear it anyway.
Case 4720, 5 respondents, Castello Holdings LLC at 1487 Gulf Bay Boulevard, in violation of code for exterior services, door and window openings in abandoned building, and issue an order with compliance deadline and fine if compliance is not met. Yes, sir.
Hello, my name is Sam Lee. I am a certified general contractor here representing Castello Holdings.
Mr. Lee, were you sworn in?
Yes, ma'am. Whenever.
Okay. And you're going to be doing the work, is that it?
No, ma'am. Here for Daniel, the owner, to explain what he plans on doing with the property and just asking for an extension date. And I've already talked to Mr. Castman about a 60-day extension versus a 30-day for a new owner that's under contract right now to close on the 20th of March, and at least giving them enough time to pull the proper permits, because they will need permits in order to correct these issues.
So, the current owner admits to the violations,
Yes,
is that, okay. All right, if you'll have a seat.
I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor? Motion carries. Okay.
Daniel Casman, Code Inspector for the City of Clearwater. This is for case 47-2020 for 1487 Gulf to Bay Boulevard. 3 violations for doors and windows, exterior surfaces, and abandoned building. Under direction of council, we're willing to give 90 days for the repair, for the transition of new owners and to acquire permits. So rather than requesting compliance on or before March 26th, could we please make that compliance on or before May 26th of 2020? Or a fine of $150 per day per violation for each day the violation continues to exist. And we're asking the board to authorize the following: after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city's attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law.
Okay, the May 26th date is to have everything done?
If they say they're under contract right now, the new owner will need to have time to pull permits as well.
Okay.
For all the issues.
Okay. Okay, can I have a motion?
Yep, second motion, I move to enter an order requiring the respondent to correct the violations on or before May 26, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Motion carries.
Good luck.
Good luck. Thanks for coming in. Case 4820. 1220 South Belcher Land Trust, Montana R&R LLC, trustee at 1220 South Belcher Road, in violation of code for exterior services and public health, safety, or welfare nuisance, a pool, and issue an order with a compliance deadline and fine if compliance is not met. Are they here?
No, he's not here.
Okay.
Good afternoon, Madam Chair. The property is in compliance at this moment. He's taking a
Declaration? Great.
Everything?
Yep.
Everything?
Everything.
I move to find respondent was violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing. Enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Motion carries. Case number 49-20, Kenneth Robinson and Robine C. Birch Estate at 112 North Betty Lane, in violation of code for inoperable vehicle, and issue an order with compliance deadline and fine if compliance is not met.
Madam Chair, the city is requesting a declaration of violation on this case.
Okay.
I move to find the respondent was in violation of the code as referred to in the affidavit. In this case, the violation was corrected prior to today's hearing. And to enter an order that no fine be imposed. If If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Motion carries. Case 50-20, David Marcula Lopez at 310 South Fernwood Avenue in violation of code for hauling trailer and issue an order with compliance deadline and fine if compliance is not met.
Madam Chair, the city is also requesting a declaration of violation.
Thank you so much.
You're on the road, Ryan.
I'm doing my best.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Aye. Motion carries. Case 51-20, Robert and Amy McGregor at 2477 Chaucer Street in violation of code for boat trailer and issue an order with compliance deadline and fine if compliance is not met.
We are also requesting a declaration of violation on this one.
4 for 4, that's not bad.
I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. When the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Second.
All in favor? Aye. Motion carries. Okay.
Ryan gets
Case 5420, boy, I'm gonna butcher these names. Fine respondent.
At least I wonder everybody.
Don't worry about it.
Huh?
Oh, okay.
My name is Raphael Sear, and I'm representing the owner of the property.
Okay, at 1936 North Midland.
Sear, just copy that for there, it's a lot easier.
Okay.
We do acknowledge that we are without a permit, but we haven't done any work that requires a permit. We did empty out and demolish the house on the day that actually she drove by when we were waiting for the contractor that was supposed to pull all the permits, who had pulled a permit for the roof already. And
Wait. We just need to first find out if there was if you're admitting to a violation.
well, we don't have a permit, but we haven't done any work that requires permits.
I know, so you have to tell us whether that's an admission or a denial.
Now, you tell me. We pulled a permit for a roof, which was done, but the contractor never, put into an inspection.
I think we need to go back where Mr. Engel was with the previous case. The inspector needs to tell us what the issue is.
Well, we need to.
And then she came by and found us emptying out the house, removing all kinds of debris and stuff.
I think you should accept it as a denial at this
Okay,
point.
let's do that. So let me have a motion.
No.
No motion yet.
No motion, forget it. Are we done?
Y'all need to slow down with these motions here.
Good afternoon, Board. Milda Espinosa, Housing Inspector. I am here to present the case 5420 at 1936 North Betty Lane. This is one violation, which is work being done without permits. Notice of violation was sent on January 23rd, 2020. Compliance with a compliance date of February 10th, 2020. Certified mail was sent down, delivered, received on the 31st of 2020, also sent out regular mail. Notice the hearing was sent on the 23rd, 2020, also received back certified mail, was received on the 31st, 2020, and affidavit was posting was done on the 23rd. This is where the location is. It's off North Highland, north of Sunset Point, south of Union, east of Kings Highway, and west of Douglas. It's a single family house. This is the front, partial front. You can see there's new fascia. This is construction material, wood in the side yard. Marble. This is opening that was there. I don't know if that was there original to the house, I have no idea. There was a broken front window, it was not covered. The second time I went out there, they took the covering down, it was a curtain. As you can see, work is being done, or has been done. There's construction material back in the back porch. There's new drywall. You can see that clearly on this picture. I believe those are new electrical pod can lights, I call them. That is new. You can see window has been framed in. Don't know if that is original to the house. This is the underside of the roof. The roof contractor came in and pulled a roofing permit. Later, he sent in a letter saying to void the permit, but the work was already done. This is also on the underside of the roof. You can see new material up there. This is the window that was broken. That's the one where I could see inside. This is the letter that was sent, and it says, void permit, no work was done. This is from the contractor for the roof.
What did it say?
It said, it gave the address. It says 1936 North Betty. Gave the permit number BCP 2019-060087. Void permit, no work was done. Somebody did the work.
That was done already by the time
And
she got the letter.
So there's a new roof on there, a permit was pulled,
and then voided out.
and then voided out,
Consequently, that means that the roof was put on and there was no permit.
and no inspection.
No inspections, no. This is the posting, my posting for the notice of violation and the hearing. So you have interior work and you have roof.
Right.
Thank you.
Thank you.
Yes.
Okay, the roof was done, and actually, like I said, the day we were waiting for this contractor who pulled the roof permit, he came, the day she happened to drop by, we were waiting for him. And then he said he was gonna pull all the other permits for the stuff that needs to be done, which is plumbing, new bathroom, because both bathrooms, to put it nicely, when we went in there and touched one wall completely fell apart because it was all the water damage that was on it, because the house had been abandoned for a long time. And it's true, we removed a lot of flooring and a lot of stuff, and also the roof had collapsed in the back, which is why there was a lot of damage when we were removing all of that. We did put some new sheetrock there, which is what you saw. That is all true. But then he was supposed to do, it became $6,500 to do that, to pull the permits, and because that for his fees and also for his for the cost of the permits. And he never pulled the permits. And then the last thing, he ghosted us, as the saying goes. When we finally found out the reason why he ghosted us is because he's in jail. Because he's been doing this to a lot of other people. And then, so we had tried 3 other contractors, and they have refused to take over his problems. And so, because they saw the stop work order, but, I could show them the letter that says, all we need is a permit. We finally do find a contractor, and we hope that he'll pull the permit next week. And then we expect to continue the work and be done by the end of March, once we get all the permits in place. So that's what we want to do. Because she inherited the house, and she wants to, and she basically wants to rent it.
Who replaced the roof?
The contractor, that's why I was.
The same guy that pulled the permit?
Yeah, that's why I was.
Why did he negate the permit?
That's what we want to know. But like I say, he's been ghosting us, so we don't know why he did that.
And you paid this fellow already?
Unfortunately.
Well, he didn't want to pay the permit fee, that's why he didn't get them.
Yeah.
So do you admit now, or you still deny?
Whatever.
It's yes or no. I mean, it's a kind of an iffy situation. That's why it was kind of a. I could say admit, fine, we need a permit. We know that. We want the permit. So that's not an issue for us.
You got caught in the middle of it.
We just, that basically, that's what
You want to comply.
we want to comply.
So we can help you.
That's all we want. We just want to be able to comply and get
I'm
it
sorry
done.
to hear that you got tipped by that.
That's what we like to hear, but that's what we see, that's what the board's for, is for compliance.
Right, and that's all we want. We want to do it, so
So
we
give me
can.
your first
Okay, so
motion.
we'll make a first motion, get this rolling here. I move to find the respondent in violation of the code as referred to in the affidavit in this case.
Second.
All in favor?
Aye.
Motion
And then, as
carries.
far as the city's recommendation, I don't think there was a date, was there, of compliance?
We haven't heard it yet.
Okay, so it's, compliance on or before March 27, 2020, or a fine of $150 per day, which is just the one violation. And after 3 months from the recordation date of such lien, if the fines and fees remain unpaid, the city attorney's office is authorized to foreclose, collect, or settle such lien using any legal or equitable remedies available under the law. And for compliance is just to apply and obtain the required permits.
Good, okay. So he's got till March 26 to comply.
I said, well, I think
Applying for a
I said
permit.
27, yes, sir.
Okay, that's pretty easy.
We'll get it for next week.
No problem.
Can I have a
And was that the 26th or the 27th?
27.
All right, I'll make a second motion. No other questions? I move to enter an order requiring the respondent to correct the violations on or before March 27, 2020. If the respondent does not comply by that date, the board may order a fine of $150 per day per violation for each day each violation continues to exist. If fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
All in favor? Motion carries.
Good luck to you.
Thank you.
Okay. May I have a motion to accept the affidavit? Oh, wait a minute.
Yeah,
There's
this
something
is
else.
this one right here. Not sure what the presentation.
Yeah, not sure.
Just just call it out, see what they say.
Oh, case 141-17, 1246 Idlewild Drive, presentation.
Board, this is just a presentation. We thought it was a good idea, with all the items and things that you do throughout the code board, you don't see a lot of the end results coming in a lot of the times, especially when it comes to stuff like standing orders, abatements, and whatnot. I just wanted to give you one example recently that we've completed out and just show you the end results of what
That's great.
several years of work. So this is for case number, or excuse me, for 1246 Idlewild Drive. This case was opened in June of 2017 and it went to the code board that August by Inspector Ali Stewart. I took over the case shortly after that. During that time, they were found in violation and accrued over $270,000 in liens. The gentleman would not come into compliance, so we decided to move into another direction. I came back to the code board in 2018, so the liens were stopped, and we actually moved into the abatement. This is actually where you guys issued your first standing order for abatements to be able to go back to the property over and over. The property was abated 5 times in 5 months, so we cleared out the property, we filled it up again, we cleared it out, filled it up again. The agencies involved also include police, fire, housing. Solid waste was a major help for that. And what that would,
The neighbors came in also?
the neighbors came in, yes, this was years of complaints on this property. To date, from the time we did those 5 abatements, we removed over 50 tons of debris and trash and items from this is just the outside of the home. To give you a perspective, that's 25 cars, or about half the dry weight of the Space Shuttle Endeavour.
Oh, jeez.
So, a lot of items.
This is before. This is a before shot. This is actually a very cleaned up before shot after we've abated it. I believe this is our third or fourth time that we've cleared the property out. And to give you an idea, it's hard to describe how much material was in the backyard. So I wanted to show this real quick.
I remember this case.
Yes, yes, sir. This was from the side of his yard going into the back of his property. We had a complaint, he had a person living in there with him, they gave us permission to go into the backyard.
Yeah.
So I'll just let it run here for just a moment, just to show you the sheer amount of items in that yard.
Flea market.
Yeah, there's.
I heard code.
This was his backyard. This is what we walked into.
So you would clear it out and he'd fill it up again?
He'd fill it right back up again. So. And there is a shed back there, there's a boat, there's actually an illegal structure. He actually moved in a little mobile home unit out of there, so, or into that property there. After those 5 abatements, we were moving towards demolition, getting very, very close to it, and we convinced him through his family and talking to him to sell the property and move out. He moved out in June of 2019, and a stipulation agreement was created Mr. Fuino and the new owners, and they were given about 6 months up until December, January timeframe to fix the property up. So.
How about the 270, did it come, did we reduce that?
I'm not sure I believe it was if they fixed all the violations, there was a small fee, like administrative fee. Yeah.
It was what, Mike? $9,000.
Right.
So you have to come 50 tons.
Because of the contractors you had employed.
Our first cleanup, we had rotating rear end city residential trucks in both driveways. They would fill it up, they'd come out, a new one would come in. And I believe we had 8 to 10 of those the first day. So before, here we have from 2018, and this is what it looks like now.
Wow.
With the new owners. This is from last week. They've taken out the driveway, they've enclosed the garage.
Oh, that's nice.
Very nice. I appreciate that. That's nice to share it.
So we have again from 2018.
Yeah, put that on YouTube.
And again, this was the biggest part was getting all this material out of here. So before and after the backyard, and when I say that there was glass of every color sitting on the ground, not a blade
For
of
the
grass.
city to reduce that from 270 down to 9,000, that's awesome. I mean, there's some cities not far from here that wouldn't do that.
Right.
He was hoarding.
It was a hoarding situation.
It's a mental health.
This was our only view into the home from the backyard. There was actually a door frame or a wall or something he had knocked out from the kitchen area. And the one picture to the left is piles of clothes that went into the property or inside the home itself. And that's what we have now. Again, cleaning up the backyard, the illegal structure that was back there, the little mobile home unit next to the boat, and then now.
Very good.
Not even a single house.
No, sir, it was hard to recognize. We were allowed access in once. When you open the door, that's the door opening up. There was a wall from the entrance all the way to the back. You could not get access about 3/4 of the home. All you could do was go down the hallway straight into the bathroom, into the one room to the left, the other one he had nailed shut. So, and then again, our only views from the house from the back into the inside of the home. This is what the inside of the home is now. They've knocked down that wall.
Look at that.
Amazing.
As you said, it wasn't even recognizable when we opened it.
Yeah, it's really nice.
My mother-in-law was a hoarder.
Is it just
Just like
these?
that.
Yes, sir. Sure is. So with that, we just wanted to show you. Thank you again for the work you guys did, and just wanted to show you an end result, a 3-year, almost 4-year work.
That's awesome.
So, all right.
Very good.
Thank you.
Thanks.
Thank you, Sam. We appreciate that.
So the point is that the work that we do here does not go unnoticed, and I know generally hear a lot of bad, and some of the
It's good to see the good once in a while.
Okay, may I have a motion to accept the
I move to accept the affidavits of compliance as listed.
Second. Not that easy.
Compliance.
There's probably somebody there.
Okay, sorry.
Sammy, you made our day.
All in favor?
Are we okay with all?
Yeah, but now we got the non-compliant.
Right,
Well,
so we need a motion. We need-
I second.
All in favor? Motion carries. Okay, non-compliance.
I love that name.
Is there anyone here to speak to the affidavits of non-compliance?
Okay. Mr. Plunkett's
To which case are you speaking to?
Case 86-17.
5.2.
5.2.
Okay. Would you identify yourself, please?
My name is Sylvia Tsitsikas, 249 Bayside Drive, Vero Beach.
I've got it here.
5.2.
Please tell us about the violation.
Jason Cantrell, Building Inspector.
Great.
I thought I could help out here. This was cited as an, excuse me, as an unsafe case, mainly because of the accessible pool that was not maintained. And this home is under construction right at the moment. It has been for quite some time. She's working on that. However, the pool is the issue here, so she's going to speak on that.
There was a permit for the pool, but the permit was voided by the contractor because he was not allowed access back on the property to finish the pool.
So it's an unfinished pool?
Yeah,
Correct.
Right. We're getting a new contractor to finish off the pool.
So what does the city recommend?
Well, this is an affidavit of non-compliance, so it's either approve, don't approve, or if you wanted to get permit.
Yeah, but there has to be a problem here. What's the problem?
The pool.
I mean, you don't want us to accept it
We just
if
need
there's
more.
a problem, right?
There's a safety issue here because it's open to the public,
Correct.
anyone can get in?
Correct.
Well, you need to establish a barrier then,
Yeah.
until it's done.
Correct, we've been talking about that today, trying to figure out what exactly we needed to be covered until we get the permit, the new permit, or if it needed to be.
Okay, so when
So I
did,
just need some more.
when did we first start the case?
Excuse me. She's working with an architect and has been trying to get plans for the entire house in place. She does have one active permit now for that work. She was a little confused and did not realize that it was just the pool that is our issue. Okay, so the notice of violation originally was sent October of 2018.
Okay, so
2018.
we're here a year, and almost a year and a half, this has been going on.
Correct.
So if I make a motion
It's a long time.
right now to not accept this affidavit of non-compliance, it'll come back before us? Is that the way I'm reading it?
If you accept the affidavit today, then.
Andy, is that what's happening?
Probably what we would, depending on what you decide to do, is that we would reset it for another meeting for either acceptance or rejection. I wouldn't, not accept it. I would continue it if that's what you so choose, but I haven't heard how much time is reasonable in this situation.
Well, she said they're kind of just talking about it.
So,
I know that's the concern.
Yeah.
Right. What do you recommend, 30 days?
They were given originally until November to come into compliance.
okay.
And so what's necessary for compliance? Just do a border around the pool?
No, she would need to obtain a permit. And have
They obtain a permit?
permit originally to put that structure in, didn't they? Or not?
Correct, but the contractor voided the permit because he was not allowed access to the property to finish the work.
So would we need more than 30 days for them to get the permit? Or is 30 days sufficient?
Yes, a pool contractor can pull a permit probably within 4 days.
But the issue is safety of the open pool.
So what's the city recommend? Help us with
Well,
the
Mike's
timeframe,
gonna
and we'll
say-
continue that.
Mike's gonna give us.
I just want to be clear, ma'am, have you cleaned up the pool?
The pool is clean. I was gonna cover it, but I didn't know, I didn't realize it was the pool issue. I thought it was the whole permit issue. So the pool can be covered.
Do you have pictures, current pictures?
I don't at the moment.
So there's no concrete base, is there? You have grass.
No, there's grass around the pool and then there's.
No, if you see the picture that we're seeing,
Yeah, oh no, yeah, it's,
Just dirty water.
that's dirty water. It's-
But there is dirty
so
water?
that's
Not
actually,
anymore, but there was.
No, I'm saying right now.
Oh, yeah, no.
So
that looks like what, maybe a foot of water? Was that like a foot of water or rain?
Yeah, it was raining water. It was raining water at the time.
Okay, just so you know, you originally compliance was June of last year.
So, my question,
When did this all start? So this has been going on for well over a year.
Yeah, I'm surprised that this is not before us as a repeat.
Board, so this is an affidavit of non-compliance. Typically, you accept these all as one. Now, each individual property owner has they're allowed to come and speak, or they always were, but we'll let them know when they come in. So it's up to you to accept it or deny it.
Okay.
Or continue.
There's nothing, there's no more time, there's no more, unless it's something that the staff's working, or we can continue it.
Okay, so we can, the way I look at it is you've had this time, nothing has transpired. Maybe you had misunderstandings, so we have nothing to do with that.
Right.
So you haven't complied, so I believe that. So I would say she hasn't complied, we're done with it, let nature take its course. Now, I think you would like for us to say, don't do that, let me get a permit and get this thing
No,
done.
I wanna get it taken care of. I mean, can I cover it? Can I do anything until the permit is done? What would
We
you like me
can't
to
tell
do?
you that.
I mean,
So do
I'm
we
working.
want to accept?
Just,
Yeah.
That's just common sense, ma'am, you could have done that.
Well, yeah, there's a gate on both sides. I mean, there's a gate to.
and there's the
doesn't
water
sound
on the
like
other
open.
side, so I don't see, this is not like the neighborhood pools we've seen where
No.
there's no structure around or no fence or something. So there's not a real safety hazard, it's just, you haven't done anything is what the problem is.
We pumped the pool out, but I didn't realize it needed to be covered.
Either way, it's been since June.
It's a safety hazard is what you have to do.
So I'm gonna make a motion to accept and we'll let nature take its course.
That's
What is that?
what I would do.
Is there a second?
She goes and sees the city.
I'm gonna make a motion, 5.2, case 86-19, accept the affidavit of non-compliance.
Second.
All in favor?
Sure.
Accepted.
And then Andy, how about all the others? We're gonna just bundle that?
No,
We have
there's
to see
another
if
one.
people here, we have some people on the other cases.
Gotcha.
Hey, gentlemen.
5.3's been continued,
Right,
and 5.9 is going to be continued also.
all right.
All right, so
There's a gentleman for 5.6.
Mr. Plunkett, are you going to address your guys?
Yeah.
Ask a question? Oh, I'm sorry.
I'm asking that 5.6 be continued too.
Okay, hold on one second.
Okay. Yes, ma'am?
If your question is for what you need to do, you need to talk to this gentleman over here, not the board. The board just decides whether or not there's an affidavit accepted or not. So you need to just talk to him.
He needs to address this next case too. Thank you. Okay. Sorry.
Which case is this,
This
sir?
is 5.6.
He looks familiar. Yes, sir.
Go ahead, Mr. Point.
Come on.
I would request that I get a continuance till next month. Which case are we on?
5.6.
Would you identify yourself for the record, please?
Yeah, Michael Plunkett.
Yeah.
Okay, if I remember correctly, sir, living there, but there's no utilities, and we understand your story and all that.
Correct.
Right, you were supposed to tear it down, and you applied to some other board, and they said, they told you to take it down, never happened. So, is there something changing for you, that you think?
What's changing is that I'm in serious negotiations with my family up in Rhode Island to see if we can do something. Another month would really help me. If I can't do it by then, I'll step aside and just please go ahead.
What if they?
Carl, have you been speaking with Mr. Plunkett on this?
I haven't heard from him in a while.
Okay.
It's been a month or so.
What was his compliance date?
We're gonna pull that.
Compliance date was October 25th, 2019.
Right. You were showering at the Y and that kind of thing, right?
Yes, ma'am.
Yeah, okay,
Yeah, we remember.
all right. Let's accept it. Yep.
5.6, case 195-19, I move that we accept the affidavit and let nature take its course. I like that, that should be in the
So,
language.
I have a question for the city. In this case, how much time do you think there's gonna be before you take any physical action regarding this property?
Actually, own it, that's what you're saying. It would, before we get the trucks there, it would probably take 2 to 3 months.
Okay, so, Mr. Plunkett, here's the thing, it's gonna be 2-3 months on their part before they do any physical action. You're looking for a month because of your thing, so I think there's ample time for you to get that. If you can get that resolved, you've got time to work with,
Okay.
okay?
Thank you.
Thank you.
Okay, I need a second to the motion to accept.
I second it.
All in favor?
Aye.
Motion carries. Okay, anyone else on non-compliance? Okay. Okay,
We need a motion on the remaining.
yeah.
Okay, I move to accept the affidavit of non-compliance for all remaining cases and issue an order that imposes fines and states if fines and fees remain unpaid 3 months after such lien is filed, the city is authorized to foreclose, collect, or settle such lien.
Second.
All in favor? Okay, nuisance abatement liens. Is there anyone here to speak to nuisance abatement liens?
How long has somebody had their permit?
I make a motion that we accept the, all the nuisance abatement lien filings in their entirety.
For case 5620, that's a declaration of violation of that one.
I'm sorry, which one?
That's 7.1.
7.1, that's a declaration of violation.
Okay.
Okay,
So we can take a separate vote on that one and then the remaining.
I move to find, this is 7.1, case
5620.
56-20. I move to find the respondent was in violation of the code as referred to. The affidavit in this case, the violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may order a fine of up to $500 for each day the violation continues to exist.
Have a second? All in favor?
Aye.
Did we read the right code? By that I mean saying, should this have been page 8 versus the other declaration?
I read the one on page 2.
Yeah, I'm talking about page 8 deals with violation for nuisance abatement. Was this a nuisance abatement?
Yes.
Yeah, so we read the wrong one.
Okay, I'm sorry.
All right,
I
scratch that.
take that back. I amend it. This is case 7.1, or excuse me, 7.1, case 56-20. I move to find the respondent was in violation of the code as referred to in the affidavit in this case. The violation was corrected prior to today's hearing, and to enter an order that no fine be imposed. If the respondent repeats the violation, the board may impose a daily fine and order the city to take all reasonable reasonable actions to abate and maintain the nuisance, including entry onto the property, and to charge the respondent with those costs, fines, and fees, which will become a lien on the property.
Second.
All in favor?
Aye.
Motion carries.
So I make a motion that we accept the rest. That would be 7.2, 7.3, and 7.4 in their entirety.
I second.
I have a question though. The second one here is the property on Chestnut and Myrtle. What does that do with
The other guy, the guy who has the interest.
Why don't we take that 7.2 you're talking about?
Yeah.
Why don't we just take that one and, push it first status conference in June?
Is that 7.2?
Yeah.
You could just do, the city could just remove that from the lien filing. Yeah.
Okay.
Do you want me to continue it, or?
No, just the city can, just put that one back on when they're ready.
Okay.
Okay.
Not on 7.2.
We would have issued an order.
You're not doing anything because the city doesn't want to do anything yet.
The motion was to issue an order.
I know, but we're removing that one from that. You want me to have to do a new
We
motion?
adjourn?
Can you do a new motion on the nuisance abatement lien filings?
Mr. Kraft?
Just doing 7.3 and 7.4?
Guys,
Mr. Kraft?
I think so, yes.
Yeah, can you just do a new motion on that? Just accept the nuisance abatement lien filings for 7.3 and 7.4?
Okay, I make a motion that we, 7.3, 7.4, that we accept the nuisance abatement.
Perfect.
is there a second?
Second.
All in favor?
Aye.
We are adjourned.
Yay!